Order. Without objection, the chair is authorized to declare a recess. We welcome you all to the hearing today, and please stand as the gentleman from North Carolina leads us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. I thank everyone for coming, and I'm told others are on their way. I hope that's true. I recognize myself now for an opening statement. I thank the members who are here and those who will be coming, and I thank our witnesses today. This is really a great panel we have, and a lot of talent, expertise, and I'm grateful that you would take time to be with us today. Today's hearing is titled Criminalizing America, the Growth of Federal Offenses and Regulatory Overreach. We could have just as easily called it Oversight of Congress because we created the problem that we are here to discuss today. The problem is the number of federal and regulatory crimes has simply escalated out of control to the point that law-abiding Americans unknowingly commit several crimes every day. According to one study, the average American commits 3 felonies per day, which does not consider the overwhelming number of misdemeanors or civil violations. In some instances, the laws are so obscure and vague that even law enforcement and federal agencies are unaware that they even exist. The U.S. Code is estimated to contain more than 5,000 crimes today, and I'll hold it up for you. This massive tome is the Criminal Code. Just a decade ago, some scholars estimated there were approximately 4,500 crimes, and the fact that these numbers are just estimates underscores the severity of the problem. According to a study by the Federalist Society, the number of federal criminal offenses increased by 30% between 1980 and 2004. There were 452 new federal criminal offenses enacted between 2000 and 2007, averaging 56.5 new crimes per year. And over the past 3 decades, Congress has been averaging 500 new crimes per decade. And keep in mind that these estimated 5,000 criminal laws are not all neatly tucked into Title 18. Rather, they are scattered around the other 49 titles as well. The fact that this is only an estimate means that no one knows exactly how many federal laws subject U.S. citizens to criminal sanction. That includes Congress, the Department of Justice, and other federal agencies responsible for enforcing those laws, let alone your ordinary American. I called, when I first got elected, this is an issue I wanted to take care of. And so 8-9 years ago, when I was here, I called Congressional Research Service, and I said, how many crimes do we have, not just in the federal code, but through regulatory agency? They said, I'm not kidding you when they said, and I tell you this, they said, no one knows. And I thought that is impossible, that no one knows. But estimates have that at over 300,000. And so I guess it truly is, no one knows. So how did we get here? After all, our founding fathers first enumerated federal crimes in the Crimes Act of 1790. And that act enumerated 23 federal crimes and established punishments for those crimes. Among others, the Crimes Act of 1790 established crimes for treason, piracy, and counterfeiting. While the legislation did establish some crimes against the person, such as murder, and crimes against property, such as larceny, the federal jurisdiction of those crimes was limited to federal property and federal territories. Over the past century, Congress has lost its way. Instead of methodically and deliberatively crafting a common-sense criminal code, Congress acted in a knee-jerk reaction to every minor and major crisis. In doing so, Congress believed that there always had to be a federal response to every headline and every breaking news story. So, one academic has aptly noted, quote, it was the spate of bank robberies by John Dillinger in the 1930s that provoked passage of the federal bank robbery statute. The kidnapping of the Lindbergh baby about the same time caused passage of the federal statute on kidnapping. The assassination of President Kennedy in the early 1960s prompted the statute on presidential assassination. And the killing of Senator Robert Kennedy in the late 1960s that resulted in the passage of a statute finally making it a federal crime to kill a member of Congress. More recently, we saw the enactment of Sarbanes-Oxley in response to the Enron scandal. All of us on this dais have witnessed this phenomena among our own colleagues. Some have termed this the accumulation approach to offenses, whereby Congress has simply accumulated new offenses for 200 years or so with little examination or reformulation of existing offenses, which has resulted in serious overlaps in coverage and irrationalities among offense penalties, which create new possibilities for disparity in treatment and for double punishment for the same harm or evil. And this leads to absurdities. For example, the Code of Federal Regulations makes it a federal crime to sell a quarantined zebra while it is still in quarantine. In another, 16 U.S.C. Section 703 and 50 CFR Section 20.91a make it a federal crime to offer to buy swan feathers for use in making a woman's hat. According to one scholar, the proliferation of crimes makes it extraordinarily difficult to ferret out the law applicable to a particular factual situation. It also creates unfairness within federal law, which provides federal prosecutors with a near limitless menu to pursue criminal defendants. And when Congress isn't creating new criminal code provisions, it is passing laws that allow unelected bureaucrats to write regulations that carry civil and criminal penalties. To make matters worse, many of these regulatory crimes are strict liability crimes. Many ordinances do not have mens rea requirements. Therefore, these ordinances make it a violation of law regardless of whether someone intended to break the law in question. As a result, Congress wrote and passed a slew of strict liability crimes in which a defendant was not required to possess the mens rea typically required to establish guilt of the accused. This resulted in both federal agencies and Congress using regulatory crimes as another tool to penalize arguably innocent citizens, resulting in the deprivation of liberty and the loss of rights, such as the right to vote or possess a firearm. What we all too often forget is that many of the problems we seek to solve are actually state and local issues. Under the federal system, the United States Supreme Court has observed that, quote, states possess primary authority for defining and enforcing the criminal law, and our national government is one of delegated powers alone. Under our federal system, the administration of criminal justice rests with the states, except as Congress, acting within the scope of those delegated powers, has created offenses against the United States. But Congress has not relented and continues to add federal crimes to our federal code. Congress can and should restrain from over-legislating on issues that should be left to state and local governments. This hearing is an opportunity to examine potential legislation introduced in past Congresses to restrict federal agencies' ability to criminalize conduct that a reasonable person would consider lawful. Thank you. I look forward to hearing from our witnesses and the members, and I will yield back and recognize the ranking member, Ms. McBath, for her opening statement.
Well, thank you, Chairman. And I want to thank you to our witnesses today, those of you that I was able to shake hands with, and Mr. Tolman, I'm sorry I didn't get a chance to properly thank you for being here today. But thank you for being with us on this hearing on overcriminalization. Our criminal justice system has many important purposes, laying out the laws that, if followed, prevent us from harming one another and making our country safer. Our criminal laws prohibit murder, drug trafficking, and fraud, and impose harsh penalties for those who harm others, whether it be physically or financially. Many of our laws are written clearly to achieve this goal, and many of our law enforcement officers and prosecutors use their judgment to prioritize cases in which they can address the gravest injustices. But unfortunately, some of our laws are not well written at all, and some actors in our justice system do not have their priorities in order. Whether due to misguided leadership or lack of resources, charges are sometimes brought against those who are the easiest to prosecute rather than to those who have caused the greatest harms. Often, this results in the disproportionate incarceration of people of color, people with limited financial resources, immigrants, people suffering from addiction, and even people who are actually victims of crime, such as those who commit crimes while being victims of human trafficking. Overcriminalization, the proliferation of federal crimes that cover more and more conduct, exasperates this problem. It leads to more surveillance, profiling, and targeting within the minority communities. It allows for people to face multiple charges for one criminal act, lengthening their sentences and increasing mass incarceration. Minorities are already subjected to harsher penalties for committing the same crimes, and the variations of potential charges brought on by our laws allow for even more variability, increasing the potential for discrimination in a system that is supposed to be impartial. Because of this, communities have lost trust in public safety and the overall system. Many don't feel safe, and they don't feel supported enough to call the police when they witness a crime or provide a tip that may break open a case for fear of being arrested themselves or prosecuted, which in turn making it even harder to prosecute serious crimes. This problem is especially troubling given this administration's stated priorities. President Trump has already repeatedly vowed to use the criminal justice system for his own interests, rounding up the nonviolent immigrants and people who look like immigrants, pursuing his political enemies, exonerating grifters, and even mass pardons for those who violently assaulted our police officers here in Washington on the Hill January 6, just because they did so in the name of Trump. This is an incredible abuse of our criminal justice system, which should be focused on preventing and prosecuting violent crime, preventing theft of families, hard-earned savings, and holding corporations accountable when they harm workers and our consumers. We need to return to an evidence-based policy agenda that actually use our limited resource to make us safer. That's why I'm proud to co-lead, along with Congressman Roy, Ranking Member Biggs, and Congressman Cohen, the Count the Crimes to Cut Act. This bipartisan bill would require the Attorney General to provide us with a report detailing all federal crimes, including the elements, the potential penalties, and the number of prosecutions in the last 15 years, and the mens rea requirement, which asks what the mental state of the person was at the time that they committed the crime. This will help us look for places where we might eliminate policies that simply don't make sense, so we can make sure that our criminal justice system is focused on what really, really matters. I look forward to hearing more from each of our witnesses today about this bipartisan bill that will directly address overcriminalization and other ways that we might be able to address this ongoing problem. And I ask in unanimous consent to enter into the record a statement for the record on today's hearing from the National Association of Criminal Defense Attorneys.
Without objection.
Thank you. And with that, I yield back.
Gentlelady yields back. I'll turn to the ranking member of the entire committee, Mr. Raskin, and yield to you, if you'd like.
Thank you, Chairman Biggs. I appreciate it. And thanks to the ranking member, Ms. McBath. Thanks to the witnesses for joining us today. Criminal defense attorney Mike Chase has documented some of the most preposterous crimes in the federal code. For example, it's a federal crime to sell Swiss cheese without holes in it. Some people prefer Swiss cheese without holes in it, but it's a crime to sell it. It's also a federal crime to receive through interstate commerce a small toy ball that doesn't contain a warning that says this toy is a small ball. And apparently it is still a crime to sell canned green beans and call them stringless unless you're sure they are in fact stringless. So prosecutors may be unlikely to charge some of these ridiculous crimes on their own, but overcriminalization is a serious problem nonetheless because it's an invitation to arbitrary prosecution and selective political prosecution. We can see and quantify who the overcriminalization problem affects most directly: people who are at a social or economic disadvantage, people who don't have the lawyers to defend themselves against such prosecutions with, immigrants, people with disabilities. Between federal, state, local, and tribal criminal justice systems, nearly 2 million people in the U.S. are incarcerated, costing taxpayers $182 billion a year. Congress often crafts new criminal offenses and expands existing crimes without considering whether the federal government should even be involved in the underlying conduct. Recent studies estimate there are nearly 5,000 statutory federal crimes and between 300 to 400,000 crimes in the regulatory code. According to one study, Congress created 56 new crimes every year from 2000 to 2008, despite the fact that crime rates were actually declining during this time period. While federal criminal law plays a vital role undoubtedly in protecting the public, it should complement state law rather than duplicate it, and it should not be the source of an extraordinary burden in the lives of the people. Some people have seemed to escape the trend of overcriminalization. Criminal prosecutions of white-collar crimes, from public corruption to tax evasion, have been declining for decades. Under the current administration, those statistics are likely to plummet further, given the Department of Justice's gutting of the department's top anti-corruption unit and its removal of its own power to charge politicians and public officials for bribery and extortion in some cases, its disbanding of anti-corruption task forces, and its purge of veteran prosecutors and agents who are dedicated to public safety, but who have run afoul of the new pinched political correctness standards of the administration. These changes have taken a bad situation and they made it worse. So instead of playing politics and trying to prove who's tougher on crime, we should work in a bipartisan manner to craft evidence-based policy that keeps all of us safe. We could do more to fight crime by addressing underlying issues that give rise to crime and thoroughly studying the criminal code. During last week's House Judiciary Committee consideration of the reconciliation bill, I tried to restore funding to hundreds of critical grant programs that were cut by DOJ. Unfortunately, my colleagues refused to even discuss them and yet voted against our amendment to restore funding to these programs addressing the needs of crime victims, victims of rape and sexual assault. I think that we can all agree that we need to make sure that our federal criminal laws are clear and fairly enforced. We cannot have a criminal justice system that holds the president's allies above the law, gutting enforcement of fraud and corruption offenses and pardoning January 6 cop beaters and fraudsters who happen to be allies of the president, while threatening criminal prosecution against journalists, politicians, and peaceful protesters who speak out against the current administration. I look forward to working with my colleagues to ensure that the federal criminal code and its enforcement serves the public safety of all the people. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. I will now introduce today's witnesses. Start with Mr. Brett Tolman. Mr. Tolman is the founder of the Tolman Group, a public policy law firm that works to hold federal, state, and local governments accountable and advance transparency. He's also the executive director of Right on Crime, an organization that advocates for criminal justice reform. Mr. Tolman previously served as the United States Attorney for the District of Utah and has testified before Congress multiple times on criminal justice issues, including the First Step Act, and many times before this committee. Welcome, Mr. Tolman. Thank you. Mr. Jonathan Turley, Professor Jonathan Turley is the J.B. and Maurice C. Shapiro Professor of Public Interest Law, Director of the Environmental Law Advocacy Center, and Executive Director of the Project for Older Prisoners at the George Washington University School of Law. Professor Turley has written and litigated on a wide range of areas of the law, including the question of overcriminalization before us today. He has also testified here and before this committee a number of times. Mr. Giancarlo Konoparo is a senior legal fellow at the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation. His research focuses on constitutional administrative law, civil rights, the rule of law, and the courts, and he was the co-author of the study that almost everybody up here has referenced already, iterating something in the near order of 5,200 federal crimes in the current federal criminal code. Thank you for being with us. Mr. Michael Fox is a legal fellow at the Cato Institute's Project on Criminal Justice. His research focuses on overcriminalization, policing, and the criminal justice system. He previously served as a public defender in Colorado. We welcome each of you today. Thank you for being here. And we'll begin by swearing you in. Would each of you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect that the witnesses have answered in the affirmative. Thank you each. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. If you're getting close, I tend to tap that, kind of give you a 15-second warning, and then I really hammer it no, I'm just kidding. We want to get it as close to the 5 minutes as possible. So we're going to start. We're just going to go down the line today. We'll begin with you, Mr. Fox. You are recognized for your 5 minutes.
Thank you, Chairman Biggs, Ranking Member McBath, Ranking Member Raskin, and distinguished members of the committee. It's an honor to speak to you today about the rampant overcriminalization and the very real impact it's had on people across the nation. We are a nation of too many laws. As it's been said, over 5,200 federal criminal statutes alone, and that's not counting the over 300 to 400 federal regulations, despite having never been passed by Congress, can land Americans behind bars. The federal government is one of enumerated powers. Yet this important limitation hasn't stopped Congress from enacting criminal statutes that far exceed the legitimate ambit of the federal government, nor has it stopped the Justice Department from enforcing laws in a manner inconsistent with constitutional limits or legislative intent. With so many laws and regulations, it's easy for good people to become entangled in our criminal justice system through no fault of their own. While leading a shark diving charter, John Moore and Tanner Mansell stumbled upon what appeared to be the work of poachers. They cut the line, freed the sharks, and reported it to authorities. That would change their lives forever. Unbeknownst to Moore and Mansell, it was actually a bona fide research project. In an act that defies common sense, Assistant U.S. Attorney Thomas Watts Fitzgerald charged them with felony theft within the maritime jurisdiction of the United States. The trial judge didn't give the defense requested jury instruction explaining what rational people would understand to be theft, the wrongful taking of property with the intent to deprive the owner of the use or benefit and convert it to the use of oneself or another. The juror sent 7 notes to the judge begging for a way to acquit before reluctantly convicting Moore and Mansell. The 11th Circuit Court of Appeals affirmed. Nevertheless, Judge Barbara Lagoa lambasted the prosecution and castigated Watts Fitzgerald by name for his imprudent exercise of discretion in choosing to prosecute the case. Judge Lagoa highlighted the sheer absurdity of branding Moore and Mansell lifelong felons for engaging in conduct that no rational human being would interpret as criminal. Our system was painstakingly designed to discourage ill-conceived prosecutions and palpably unjust convictions, yet it plainly failed to do so here. At the founding, the greatest protection against unjust convictions and excessive punishment was the citizen jury. The framers understood that depriving a human being of their liberty should not be easy. The government had to prove to a jury that a given prosecution was wise, fair, and legitimate. Jurors would scrutinize the government's actions with a fine-tooth comb and ensure that the sentence was proportionate to the wrongfulness of the crime. Jurors had a civic duty to acquit against the evidence as justice demanded. It's indisputable that jurors still have this important power today. Devoid of juries is a meaningful safeguard against an overly punitive government. It's all the more important that we robustly apply other core defendant-protecting doctrines. At common law, prosecutors had to prove that a defendant knew or intended to commit a crime. This is known as mens rea. It's highly doubtful that a jury, cognizant of its historic power to acquit against the evidence, would have convicted Moore and Mansell. It's highly unlikely Watts Fitzgerald would have even charged them had he known that a jury could call his bluff. Likewise, had the jury been given a narrow instruction on the definition of the word theft, jurors likely would have acquitted as well. You too can easily become a criminal. It's as simple as walking your dog on Supreme Court grounds with a standard 6-foot leash, where the maximum permitted length is only 4 feet. Any longer, and you could be looking at 60 days in jail. No one is aware of this regulation because there's no signage putting potential violators on notice, yet any one of us could be charged with violating it, despite the reality that no reasonable person would understand this to be against the law. There are many actions Congress can take to mitigate these profound injustices. Here are some examples. Draft prescriptive legislation. Repeal statutes that confer blanket criminal lawmaking authority on federal agencies. Include a mens rea component in every new statute. Establish a default mens rea setting where existing statutes are silent. Mandate that federal judges inform jurors of their historic prerogative to acquit against the evidence. As Justice Gorsuch notes in his recent book, criminal laws aren't the solution to every problem. A criminal justice system must be perceived by the public as legitimate to be effective. A system that seeks to send well-meaning people like John Moore and Tanner Mansell to prison over a veritable mistake merits neither our confidence nor our respect. I'm eager to work with you to change that. Thank you for holding this important hearing, and I look forward to your questions.
Thank you. Now we will recognize Mr. Konoparo for your 5 minutes.
Thank you all very much for having me. It's my pleasure and honor to testify. My name is Giancarlo Konoparo, and among other things, as was mentioned, I wrote this report, which is, as far as we know, the most recent and up-to-date count of the crimes in the United States Code only. I want to begin with the ancient Roman maxim that ignorance of the law is no excuse. That old rule makes very good sense when the law prohibits things that are morally wrong, like murder or kidnapping or theft. And because every person knows that morally wrong actions are often illegal, and it's fair to presume that people know that. We can also fairly presume knowledge of some laws that are morally neutral, what lawyers call malum prohibitum crimes, provided that those crimes are well publicized, not too numerous, and based on common sense, like, for instance, the rule against smoking in this building. But what if malum prohibitum crimes are not well publicized, number in the tens or hundreds of thousands, and defy common sense? What if, for instance, as Congressman Raskin mentioned, we made it a crime to sell Swiss cheese that didn't have holes in it? And what if we divided that crime among 4 different laws and scattered them pell-mell throughout hundreds of thousands of pages of law? America has, in fact, done exactly that. It is a federal crime to sell Swiss cheese without holes in it, and to know that, you'd have to consult 3 statutory provisions and a federal regulation. It's not the only such crime. In 2022, I partnered with the Mercatus Institute to deploy an algorithm to count the crimes to count the provisions in the United States Code that create at least one crime, and then to estimate the number of crimes contained therein. Our report found that the number was 5,199 crimes in the U.S. Code, but that's only in the U.S. Code. That's already more than any one person could know, but the Code of Federal Regulations includes probably hundreds of thousands of more, and as you mentioned, Chairman, nobody actually knows. Now, the Swiss cheese crime is only one example. As Representative Maskin mentioned, Mike Chase, the lawyer, wrote How to Become a Federal Criminal. It's a hilarious and depressing book about some of these most extreme examples. It's illegal to sell bacon that in a package that doesn't display the representative slice through a visual window, clear window. It's a crime to submit a design to the federal duck stamp contest if your design does not primarily feature eligible waterfowl. And again, crime to sell a marble across state lines if it's not marked with a warning that says this toy is a marble. Now, there's some laughter in the room because those examples are ridiculous, and that is the first problem with the proliferation of malum prohibitum crimes. The criminal law should not be ridiculous. Ridiculousness brings the criminal law, indeed the whole system of law, into disrepute. And it brings our lawmakers into disrepute, both Congress and the agencies, which are meant to be reasonable and competent governors and not pedantic nannies. The second problem is that if knowledge of the law is not a reality, the rule of law itself suffers. Everyone will know, of course, that they can't actually know the law, and everyone will know, therefore, that they can't obey the law, and all the while everyone will remember that they cannot justly be expected to do the impossible. Americans will rightly conclude, then, that such a system of laws is unjust and unworthy of both obedience and defense. Meanwhile, the government won't be able to enforce all those laws equally and fairly, so the rule of law will be tainted by bias or the appearance of bias, both of which are destructive to the rule of law. Now, numerosity is one problem. The lack of any intent or mens rea element is another. The intent element is a requirement as ancient as the maxim that ignorance of the law is no excuse. But at the same time that we broke the foundation under that maxim, we eliminated intent elements from many of those numberless crimes. That means that you can be guilty of violating countless thousands of federal criminal laws, even though you don't know that they exist, and even if you don't know that you're breaking them. So, for instance, the Swiss cheese crime has no intent element. So even if you don't know about that law, and even if you don't know that your Swiss cheese lacks holes, you can be prosecuted. You can find many more examples of such prosecutions in my written testimony and in the sources cited therein. The takeaway from all of this is that the proliferation of federal crimes and the erosion of intent elements has made America's criminal law both ridiculous and unfair. That status quo is terrible for the rule of law and ought to be changed. So what could Congress do? You could order agencies to count the criminal regulations and get a handle on the problem, but a word of caution, that task is beyond the Department of Justice. It may even at this point be beyond the agencies. It might be better simply to repeal regulatory crimes that have not been enforced in, say, 10 years. Meanwhile, Congress can and should create a default intent element in any federal regulatory crime that lacks one. And finally, Congress or the courts might create a limited mistake of law defense for certain malum prohibitum crimes. All these are good options. I hope you consider them, and thank you for inviting me.
Thank you, gentlemen's time has expired. Chair recognizes Professor Turley for your 5 minutes. Microphone, please.
Thank you, Chairman Briggs, Ranking Member McBeth, Chairman Jordan, Ranking Member Raskin, for the pleasure of and honor of speaking to you today about criminalization of federal law. It was exactly 27 years ago, on May 7th, 1998, that I appeared in this room to testify on overcriminalization of federal law. And I note this for two reasons. One is my birthday was just yesterday, and I didn't think I could feel any older then, so I thank you for making me feel very, very old. The second is it's something of a marking point, a navigational beacon on how little success we have had over 27 years. We are facing the same crisis of overcriminalization. There are an estimated over 5,000 federal crimes and hundreds of thousands of regulatory crimes. This would have been unimaginable for the framers. After all, in the Constitution, there was only 3 crimes mentioned: treason, piracy, and counterfeiting. When Congress got to the point of actually creating criminal code, they came up with 23. They seemed to think that was sufficient. It would be truly otherworldly for them to know what happened to the federal criminal code, particularly because they believed that police powers largely rested with the states. The danger is that it erases the line between criminal and civil conduct. And that danger is that criminal law not just is meant to create a stigma, because it's supposed to reflect an intent of harmful or even evil intent, but it also creates all types of costs for our legal system. And the framers talked about that. Madison talked about it in Federalist 62. And what they said is that you can't make criminal laws where citizens just have to guess what is criminal. It has to be the brightest of bright line rules. And instead, we have become a nation of mattress tag felons, where everything that you do can also be treated as a felony. And while we say ignorance is no excuse, the problem is that Congress has created a system where you have to be ignorant of the crimes because nobody, including Congress, knows what the crimes are. So it's hardly surprising that the citizens do not. 1 out of every 47 adults are now reportedly under some form of correctional supervision. That is also a cost. The proliferation of crimes is moving a huge percentage of citizens into the criminal justice system. It also allows prosecutors to overcharge, also to coerce plea bargains. And citizens are faced with near bankruptcy, if not direct bankruptcy, in fighting a criminal case. The Supreme Court has tried its best to try to reinforce the narrow meaning of crimes. But as Oliver Wendell Holmes said, if my fellow citizens want to go to hell, I will help them. It's my job. And the point is, as was raised in a couple of cases by the justices, Congress is allowed to do stupid things. And Congress isn't sending anyone to hell. It's created hell for the entire citizenship of this country because no one knows what is a crime anymore. And anyone can be charged as a felon. And that's wrong. Now, this is a problem of Congress's making, and Congress will have to solve it. I've suggested some ideas in my testimony, including, as was stated earlier, an effort to get agencies, preferably through an executive order, to either name all of the crimes under their jurisdiction or explain why they cannot do so. I've also encouraged the creation of a committee with a counterpart in the executive branch that can act more swiftly to reduce these. I actually believe there's one reason to be optimistic here. With the advantage of AI, and my colleague has used it brilliantly with his algorithm, it may be possible today when it was not possible 27 years ago when I spoke to this committee last on this subject. It may be possible for us to actually do something about this using AI and properly written algorithms to identify the number of crimes and to do something about them. I hope that we're all up to that task, because this is perhaps the darkest legacy of the United States Congress. It has failed the American people. It has used criminalization as a way of putting an exclamation point on their issues. That has to end. And I hope some of my suggestions may help. And I have the honor, again, of speaking with you today, and I'd be happy to answer any questions.
Thank you, Professor Turley. We're thrilled that you would spend the birthday eve with us, as you did so many years ago. And now, Mr. Tolman, you are recognized for 5 minutes.
Thank you, Chairman Biggs, Ranking Member McBath, and Ranking Member Raskin, and members of the subcommittee. Thank you for having me. I've spent 25 plus years working in the federal criminal justice system and over 15 years warning that the justice system is a powder keg waiting to blow. Let me get straight to the point. Overcriminalization is a real and growing threat to our justice system, to the rule of law, and to individual freedom in this country. Overcriminalization happens when the government creates too many laws most Americans don't know even exist. We don't know, as many have stated, we don't know the number. I'm encouraged by Professor Turley's comments that we may eventually know that number. It's not justice as it currently stands, it's chaos disguised as law. Let me give you an example, one that I learned of on Instagram, of Charles and Heather Maud. When I saw their story, I reached out and volunteered to represent them pro bono. They are a South Dakota ranching family. Under the Biden DOJ, they were charged with federal crimes over a land dispute involving a fence on property that had been in their family for over 100 years. They were threatened not only with prosecution, but they were indicted and then told that they should seek alternatives to raising their 2 minor children, Lyle and Kennedy. I was honored to fight on their behalf, and last week we announced the dismissal of the criminal case against them. It's the kind of abusive prosecution that we see all too often in our justice system. With the help of the Attorney General Bondi and the Secretary of the Agriculture, Brooke Rollins, these charges were dropped for this family, but it should not have ever happened, and it shouldn't take those at the highest levels having to review what's being done by those with this power for ultimately justice to be applied. This isn't how a free nation should operate. We are punishing people who make mistakes, not criminals, not violent offenders, just people who happen to run afoul, often of laws that they don't understand or they don't know. We incarcerate indiscriminately, and it's not making us safer. Nearly half of federal inmates are nonviolent drug offenders, and our prisons are beyond capacity. To add fuel to the fire, hundreds of thousands of Americans remain on some kind of community supervision for many years after their release, far beyond what studies have shown reduce recidivism. It's estimated $500 million and burdens on parole officers' valuable time are required now to monitor nonviolent offenders. That's why the Safer Supervision Act must be reintroduced to streamline and simplify federal supervision. It's just one tool to address overcriminalization. In addition, prosecutors have too much discretion, too little restraint, and virtually no oversight. I've been a prosecutor. I know how important those tools are to catch true criminals, but without constitutional checks like mens rea, the intent to commit a crime, we risk punishing innocent Americans for actions they didn't even know were illegal. Adding to their unsettling perception of unbridled power is the use of civil asset forfeiture, an abusive and unconstitutional way to take citizens' property without ever securing a criminal conviction. That's why I support Chairman Biggs' Mens Rea Reform Act and the FAIR Act, which restores the basic principle that intent matters. The administrative state is another part of the problem. Unelected bureaucrats are creating tens of thousands of new rules and regulatory crimes every year. 75 to 1 compared to Congress. And most of those rules are made by people who you didn't vote for and cannot hold accountable. That's why I also support Representative Chip Roy's Count the Crimes to Cut Act. It's simple. We need to know what crimes are on the books and who's enforcing them. Let's audit this system. It's common sense, and it's required if we want a constitutional rule of law in our justice system. We cannot ignore that the role of some judges are playing. When judges pick winners and losers based on politics, not law, they erode the trust in the entire system. Recent rulings on deportation, election integrity, and sanctuary cities are just latest examples. But this issue is bipartisan. Democrats have also tried to pack courts when decisions don't go their way. In short, overcriminalization fuels lawfare, undermines our Constitution, and strips Americans of their rights and dignity. It leads to over-incarceration, abuse of prosecutorial discretion, runaway regulation, and judicial activism.
Thank you. We appreciate all of your testimony. And now we'll proceed under the 5-minute rule with questions. The chair recognizes the gentleman from North Carolina, Mr. Knott, for 5 minutes.
Thank you, Mr. Chairman. To the witnesses and those opening statements, this is an important topic, and I thank you for your scholarship and for your advocacy. I will put just one single plug in as a former federal prosecutor like you, Mr. Tolman. I will say that as a society, we all have benefited from good criminal law enforcement. And there is a very distinct role and an important role in the legitimate use of the prosecutorial authorities and to combat real crime. And as an organized crime prosecutor, I saw real crime. But unfortunately, the topic that we are diving into today delegitimizes, I would submit, the use of criminal law. It weakens it and it pollutes it in the minds of all Americans. And I'm thrilled that we're having this discussion. And one of the unfortunate effects at the local, the state, the federal level, Mr. Tolman, your example speaks to this quite clearly, is it inverts the intended constitutional balance where the government should be working for the citizens. But in reality, all citizens now, because of the abuse, are working for the government, whether you're an educator, a business owner, whether you are a family, someone who's just an independent person, your ability to operate freely has been greatly hindered over the last 50 years because of the over-criminalization of what should be civil actions. And to that end, Mr. Holman, the administrative state, in my opinion, and sort of its all-encompassing bureaucracy, has been so confusing and robust in its growth that most people don't even know how to conceptualize it, respond to it, adhere to it, challenge it if there is an enforcement action of some sort. What are some ways that citizens can, how should we better enable citizens to protest and to fight back when the administrative state approaches them?
I couldn't agree more. It has been almost impossible. Two things. The Attorney General now has started a commission that will be reevaluating cases that lack that appropriate intent or that look like might have been warfare, lawfare, or politicization of the power. And in addition, Secretary Rollins, and I think other agencies should follow, has opened up a hotline for individuals to call and to identify their case and what's going on and to be able to plead their case. I only happened upon the mods based on Instagram and a social media post. I would love to know those others out there of all walks of life that are being targeted unfairly by our Justice Department.
Mr. Turley, in your opinion, what is something simple that we could do quickly to give citizens relief from these confusing patchworks of criminal enforcement? I mean, for instance, what about a reasonable care defense or something that we could afford citizens efficiently and quickly right now?
I think the challenge for Congress is this has snowballed to such a size, and it's metastasized, to mix my metaphors, it's also metastasized throughout the system.
Right.
Most of the problem here are going to be administrative crimes, where Congress creates a general crime, just leaves it to agencies to fill in the details. It's what Justice Scalia said, the fuzzy leave the details to be sorted out by courts, legislation, but he could add also by agencies. I've suggested a couple of things that Congress can do to start here to make changes in how it proceeds. One is to establish a tight rule that if you create a new crime, you have to not only go through multiple committees, but satisfy a narrow type of standard. and that standard should include a mens rea requirement. That itself would at least stop the flow from here, and then you need to focus on what has already gone through the system. And I suggest a couple of steps to try to first to gauge the exact number of crimes that we're dealing with here, but also to create a shadow system, to create a committee here and also an executive office that can work in real time together. So the part of the problem is that the delay in dealing with this, as we saw with previous task forces, is just otherworldly.
Right.
It just, the clock got burned and nothing really happened. And so I hope my testimony lays that out.
It does.
To some extent.
And in terms of just the long-term risk here, when we look at the potential criminalization of political preferences, what is the long-term risk to our country if we don't get this under control?
Well, you know, it is interesting that this is, we always have a certain conceit that the problems we face today are unique. This was a problem that the framers understood. If you make everything a crime, you make everyone a criminal, and then frankly, it loses all distinction as to what's a crime and what's a civil violation. That line between what is criminal and what is civil is key to our rule of law. Those are the navigational beacons for citizens to define their conduct. You lose that if you turn everyone into a presumptive criminal, then it changes what it is to be a citizen in this country. Basically, prosecutor discretion becomes discretion to be able to turn anyone to a felony at any time, a felon at any time. Right. And that danger cannot be overstated.
Gentleman's time has expired.
Thank you. I yield back.
Thank you. Chair now recognizes the ranking member, Ms. McBath, for her 5 minutes.
Thank you, Mr. Chair. Mr. Fox, as you know, minorities and members of marginalized communities often face barriers to accessing legal resources, including legal representation, knowledge of their rights, understanding the legal system, or the means to navigate a really complex legal system, and making them far more vulnerable to unjust prosecution and punishment. Can you kind of just expound a little bit with us today and explain how overcriminalization exploits these disparities?
Yeah, sure. So if you look at, the federal inmate population, right now it looks like it's about 156,000 people. That's a lot considering that the federal government actually doesn't have that much jurisdiction over crime. It's mostly quintessential state law, so there's a lot there. If you look, it's 35% black when the population's 14% black, 31% Hispanic when the population's 19% Hispanic. A lot of these laws, it's just, they want to go after people that have limited means, that have less resources to fight back, so that way they, they're able to sort of go after, people that they think are easy targets. And as was mentioned earlier, a lot of the people that are in federal prison are low-level, drug offenders, nonviolent drug offenders. These are not people who actually need to be incarcerated, who need to be in the system. We spent about $182 billion over the course of a year incarcerating 2 million people. And frankly, all this does is undermine people's trust in the system. There are, jurisdictions in certain cities in the country where the clearance rate for violent crimes is at or near zero. I think everyone wants violent crime solved, but when you're harassing people over things that most people would agree shouldn't be crimes, you sort of undermine the legitimacy. People are not willing to call the police. They're not willing to testify for the prosecution. When there's a lot of these communities, DC being one of them, that are both over-policed and under-policed at the same time, meaning that there's a lot of officers per capita, yet the crime rates are still pretty high because the arrests are for low-level offenses that people just really don't want to be involved with.
Thank you for that. And Mr. Tolman, how does the investigation of minor crimes reduce the effectiveness of law enforcement personnel and prevent them from addressing violent crimes? You kind of touched upon it a little bit earlier, so if you could spend a little bit more time telling us about that.
Yeah, we are not using our resources for the most important crimes, the crimes in which we need to be afraid of an individual rather than just mad at an individual for what they did. It's ironic that the one particular AUSA was referred to by Mr. Fox earlier. I actually had a case against him, and it was an individual who owned an aquarium that brought in the wrong type of fish and was saddled with a federal felony. Did not know that he brought in the wrong type of fish, and the paperwork was one of the issues. That happens every day in this country. We can talk about the crimes that are not being, that we laugh at, Many of those crimes are being used by bureaucrat prosecutors. I'm very proud of the work that I did, but the number of cases that I wish were actually aimed at the violent individuals in our communities. We've stopped working and being part of gang task forces across this country. We've limited the use of the federal resources on sex trafficking and human trafficking. We've got to get back to being good partners to our state police and law enforcement officers who have the primary responsibility on violent crime.
Thank you for that. And then also, can you kind of explain how statutes that were meant to target our kingpins, like you just said, violent crime, like the mandatory minimum drug statutes that we have yet to meaningfully reform, that's easy for me to say, how they end up sweeping in the low-level offenders?
Well, absolutely. We are in a really backwards system right now. We are using oftentimes higher level individuals in a drug distribution ring to cooperate and get credit against lower level individuals. I prosecuted many drug cases, and we rarely ever were able to get intel on the upper levels and actually take down drug conspiracy rings. Instead, we utilized, what we could in order to get low-level individuals who simply did not have the knowledge, and we didn't take the time or the patience because we didn't have the resources to investigate those conspiracies and those drug rings and cartels properly.
Okay. Thank you so much. I yield.
Gentlelady yields. Chair recognizes the gentlelady from Florida, Ms. Lee.
Thank you, Mr. Chairman, and thank you to our witnesses for joining us today. I think you have a group of members here that are very interested in finding ways to refine and streamline our criminal justice code, and you all are very helpful with the ideas and thoughtful testimony that you have brought with you here today. I would like to go back to something, and Professor Turley, I'm going to start with you. Mr. Fox told a story about a case in his opening remarks that I thought was very instructive in this way. I am a former state court judge, and in my experience, juries work very hard to follow the instructions that are given to them, most juries, and to apply the law correctly as charged by the court. What is the effect if the elements of an offense are incoherent or vague? What is the effect on the instruction that goes to the jury, and how might that affect cases that they are deliberating upon?
Thank you for that question, because it's probably one of the most important ones that the committee can tackle. The effect is huge. I spent most of my career as a criminal defense attorney, and I can say that there are certain crimes that you don't have much of an argument to make because we have strict liability criminal offenses and criminal negligence offenses. I actually testified against both 27 years ago. I think that those are two categories that the Congress should focus on, that we could do away with most of those offenses. Because once you get into court, you don't have much of an option. But so the point is that if you've got a client as a criminal defense attorney who comes on to you on one of these crimes, you've got, if you take a look at the Yates case that went to the Supreme Court of the undersized grouper, right? Those cases, while we look at them and go, my God, how did that ever be criminalized? It's a tough case for a criminal defense attorney because the judge is handcuffed. The judge is going to give instructions based on that statute. And as you say, jurors are very faithful in carrying it forth. And the judge tells them, you've got to apply this. So we have to eliminate those laws. We can't just rely on discretion. And the other thing about prosecutorial discretion, which is enormously important, because I really do agree with Congressman Ott when we talk about the role of prosecutors here. Most prosecutors, like Mr. Tolman, are very faithful and very thoughtful. I've worked with a lot of great ones. But prosecutorial discretion only works if you frame the range of discretion. So what you've done is you've blown away that frame. So there's literally discretion now for prosecutors covers conduct that everyone commits every day. That's the danger. It's not that we're not saying you shouldn't have discretion, but you're the ones who are supposed to wall in the discretion and allow them to work within it.
And staying on that point, I think that gets back to, I believe it was Justice Scalia, the fuzzy laws that we passed and then hand over to regulatory agencies. Share with us, if you will, what the consequence of that is when we leave too much discretion in the hands of the regulatory agencies to actually criminalize behavior, and have you seen disproportionate impact or exercise of that authority by different agencies?
Yes, I mean, there are certain agencies that pull the trigger pretty fast. But the point is that whether you're on the regulatory side or you are an actual prosecutor, there's a tendency to just lower the boom on people, to count stack, because what you want is to get a plea agreement. Most cases end up in pleas. So if you're on the defense side, you're looking at a client with limited funds, and those funds will evaporate the minute they start a criminal defense. And I mean evaporate within months. So they will have to sell their house, they'll have to tap their relatives, and the alternative is the prosecutor says, look, instead of my bringing these 100 counts against you, I'll let you plead out on 2 with no jail time. Most people accept that. And they then become part of the criminal justice system. They get a record. That stigma follows them. They have trouble getting jobs. They have trouble possibly getting leases. It's a horrific system.
And on that subject, Mr. Tolman, I know in your written testimony you mentioned the Safer Supervision Act, which actually discusses the intersection between community safety and successful reintegration. Briefly, if you would, tell us why you believe those types of reforms to the supervised release system are important.
Yeah, just real quickly, the states are leading on this. Conservative states are doing amazing things on this. They've realized that if we have them on supervision for a year, maybe 18 months at most, they are incentivized, they do what they're supposed to, they get on with their life. In the federal system, the average is almost 5 years of supervision.
Thank you, Mr. Chairman. I yield back.
Gentlelady yields. Chair recognizes the ranking member of the entire committee, Mr. Raskin.
Thank you very much, Mr. Chairman. The Department of Justice announced that it would demote the Foreign Corrupt Practices Act and not bring prosecutions there. It sacked 17 inspectors general when it started, people who saved us a combined $91 billion last year in ferreting out waste, fraud, abuse, and corruption in the government. It pulled the plug on the corruption prosecution of Mayor Adams in New York after Mayor Adams agreed to engage in a political alliance with Donald Trump, which then prompted the resignation ultimately of 6 or 7 attorneys, including the U.S. Attorney for the Southern District, Danielle Sassoon, who was a conservative Federalist Society lawyer and a Republican. Her number 2 also quit, saying that you'd have to be a fool or a coward to give in to this kind of pressure. Then they decimated the Public Integrity Unit. They dismantled the Kleptocracy Unit in Department of Justice. They shut down other units focused on stopping foreign interference in American politics. Mr. Fox, why is prosecuting white-collar crime with specific enumerated offenses with the definite material elements in the crime, why is prosecuting white-collar crime important?
Yeah, so I looked, it seems like there's about maybe 7% or give or take of crimes that DOJ prosecutes. It seems like that will fall under the white-collar category. I think, there's a lot of the work that the federal government prosecutes are things that far exceed the doctrine of enumerated powers, or things that the federal government has absolutely zero business getting involved in. I think white-collar crime is one that arguably can fall under the ambit of the federal government, and it's something that is important to, discourage political corruption, make sure that people are, being prosecuted because the Department of Justice has evidence that they committed a crime, and they're not being prosecuted because of, what their political views are, or that they're not being let off because of what their political views are. People don't trust a system that targets people or that ignores people based upon the views they espouse or the people they support.
So do you think that undermines public trust in the justice system?
Oh, dramatically.
It sends out the message that we have this 2-track system, one for people who engage in kind of the run-of-the-mill state law crimes like assault or theft or robbery, and then one for white-collar criminals in the government or in corporations or in politics who are able to get away with it if they know the president or they know the right person.
Yeah, I think that's right. And also goes back to the question Ranking Member McBath asked, which is, about are they going to target people who they know will fight back versus won't or won't have the resources to? So I think, that's all very related there.
Yeah. Have you studied the whole question of whether there is systematic inclusion of a mens rea requirement, so we're not putting people in jail for most regulatory offenses?
Yeah, so a lot of regulatory offenses, and frankly also a lot of statutory crimes, don't include a mens rea. The theft charge that I talked about before in the Moore and Mansell case, if I were to take Mr. Konoparo's water bottle and give it to Professor Turley, we're on federal property, technically I could be charged. That's preposterous. No reasonable person would ever think that's theft, but without an actual explanation as to what theft is that I actually intended to, take his wallet and bring it home with me, people would, they would absolutely, fall victim to these types of prosecutions, which dramatically undermines trust in the system.
Yeah, I understand that the chairman and I think Ms. McBath have this Count the Crimes Act, which suggests that we don't even know how many crimes we have. There's been such a radical proliferation of offenses throughout the federal code. But do you think it would be advisable for us, once we've counted the crimes, to propose a Cut the Crimes Act, where we get rid of a lot of the offenses that transform malum prohibitum regulatory crimes into real criminal offenses that most people would think should apply only to malum in se?
Yes, certainly. I know the chairman also has the Mens Rea Reform Act. I think those two things in tandem, if you set a default mens rea, that way, we're not sweeping people into the criminal justice system over things they didn't know would be crimes. And then also, I'm not sure it's actually possible to count all the crimes, but assuming we can do that, then we're able to sort of come to a consensus as to what doesn't belong. But I would also say if we're not able to do that, there's other changes we could do. Like I have an idea that we could just inform jurors that they have the power to acquit against the evidence when justice requires. So in a case where the Department of Justice brings a charge like the case I discussed before, where any rational person would think it's absurd, the jury can be like, you know what, we don't agree with the defense theory, this is nonsense, we're going to acquit. And that's a power they still have.
And I yield back to you, Mr. Chairman. I don't want to commit a criminal infraction here by going over my time.
Too late.
Too late, yeah. Chair recognizes the gentleman from California, Mr. Kiley.
Thank you, Mr. Chair. In California this last year, we passed an initiative to restore some consequences for things like retail theft. And my slogan in connection with this proposition, Prop 36, was make crime illegal again. Because there are some things in our state, like stealing, that are sort of classic textbook criminal behavior, that because of our criminal laws, folks could basically carry out with impunity. So that did pass. There are also at the federal level, as has been mentioned, ways in which we need to be enforcing the law against serious crimes in a more aggressive fashion. But perhaps there should be a corollary to that slogan, make crime illegal again, which is to make non-crimes legal again, which is what we're talking about today. We shouldn't be prosecuting people for buying Swiss cheese without holes, or for making a stamp with the wrong kind of duck on it, or for accidentally buying the wrong kind of fish for your aquarium. I think there are some basic, intuitive, common sense principles we would all agree a criminal code should have, that it should include things that a typical person either knew or should have known are wrong or are illegal. They should be reasonable things that make sense to people. Yes, this is the sort of thing that ought to be illegal. They should be in statutes that were issued by elected lawmakers. They should be accessible to the average citizen. They should be easy to understand for the average citizen. They should be coherent. We shouldn't have conflicting criminal laws, and they should be enforced in an even-handed manner. But none of those things are met with the current criminal code. There's a lot of, as we've discussed, strict liability crimes. There's a lot of things that aren't reasonable and don't make sense. It's a 75-to-1 ratio for crimes that are issued by bureaucrats as opposed to lawmakers. A lot of the criminal code is behind paywalls that you have to pay money to access, and then even if you can access it, you can't make heads or tails about what it says without cross-referencing the rest of the code. There's all kinds of conflicts within the body body of law. And because the average person commits several crimes a day unwittingly, it can only be arbitrary in its enforcement, and so it's not enforced in an even-handed manner. And some of the consequences for this are, number one, the diversion of resources towards prosecuting true crimes. Number two, a weakening of respect for the rule of law, of course. And then number three, a loss of freedom as sort of the default in society, as you have to walk around on eggshells, not knowing what is and is not allowed. Mr. Konoparo, I thought I'd throw out a few questions. You can address any of them, and then if there's time, perhaps the others could weigh in as well. Number one, do you think it would make sense to say that we shouldn't have any further crimes that are issued by regulators as regulations, and even those that currently exist perhaps should be reconsidered by Congress? And then also, what principles should we consider in drawing the line between criminal and civil liability? Like what sorts of offenses are more appropriate for one than the other? And finally, are there due process issues that exist because of the nature of the criminal code as it now exists?
So let me take the second one first, because I think it's the easiest one, which is I would default to the traditions that we inherited from British common law and that has been in American law forever, which is that the criminal law is meant to be for those things which are morally reprehensible. Now, that doesn't mean, of course, that accidents or sort of morally neutral things which impose harm don't get punished through civil remedies, right? But as Professor Turley mentioned, to make those all crimes fundamentally erodes that difference and changes the nature of citizenship. So that's question number two. Number one, let me get to, we've been touching on the counting and how we count and how we cut regulatory crimes, right? I think actually you can do both at the same time. What I would recommend is that you direct to every agency, and not, again, probably not through the Department of Justice, because this would be run through the Office of Legal Policy. They don't have the staff to do it. I would say probably direct every agency to send you a list of all the regulations which can be criminally enforced. And if they don't do that, any that they don't send you are cut, voided immediately. And why this is good is because there's a ton of stuff the agencies have that they don't actually use and they don't particularly need. And so what they'll do is they'll send you the stuff that they think is important. And by virtue of what they don't send you, you can sort of say, okay, the Swiss cheese kind of crimes, those go away. But here are the ones that the agencies, in their limited time and resources, thought these are really important, let's keep them. So I would say, in short, tell the agencies, tell us what's important. Anything that doesn't show up on your list is voided immediately. So you could sort of do both at the same time.
Thank you. I yield back.
Gentleman yields. Chair recognizes the gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Chair. Mr. Fox, I just curious, I was listening to your testimony and about Sacco and Vanzetti, or whoever they were, Moore and Mitchell, or...
Moore and Mansell.
Yeah, we have Moore and Mansell. What should have been the crime for cutting that NOAA apparatus apart?
Yeah, so going back to actually the point Congressman Kiley just made is I don't think it should be a crime. I think this is a
Shouldn't
thing...
be a crime to cut something that you got nothing to do with, it's not your area of jurisdiction, and to cut it and destroy it?
Well, if they intended to do that, yes, but because they didn't, I think this is sort of a civil issue where I forget the person's name, but the person who had the research project should, take them to court and they should pay for the loss of the property that was damaged. But I don't think it's the purview of the government to get involved and prosecute them for it. And this goes back to the point of why mens rea matters. If they had gone in there intending to destroy it, yeah, I think that's very different. And then that probably would be appropriate to charge them and convict them with what happened. But that's not the case here. It was a mistake. They thought they were, saving some wildlife, saving some sharks, and inevitably it was not poachers.
Just curious. I looked it up and kind of didn't think it. I think it probably should be some type of offense to destroy something that you really have no jurisdiction, and you don't make yourself the police and you make a mistake. They should have taken a deal or something, but regardless of that. Mr. Tolman, let me ask you a question. Your name was familiar to me, so I Googled it for a long time, and I didn't find any Tolmans that I would have known of. Most of them were scientists and brilliant people like you, but there was a Tolman Hall at Vanderbilt, and I think that's where it came back. Do you know Tolman Hall?
I do know the family. I tried to get into Vanderbilt Law School and was not admitted.
It's a good school, and I'm sure
Yes.
that doesn't mean anything. They get, but it's a good school. Overcriminalization. A lot of that is federal congresspeople looking for an issue du jour and passing laws that probably should be state laws. Is that not correct?
I wholeheartedly agree.
Yeah, years ago when I was a state senator, there was a group of congresspeople that came down to Nashville and all talked about carjacking, and they wanted to make it a federal law, and I suggested that it was more of a state responsibility, and they passed it, some federal law up here. And now, I don't know what it was, I read somewhere there's a new carjacking law being proposed, I think by Senator Blackburn, and it changes the duty. I mean, the standard that used to, right now you have to have an intent to murder or kill or do great injury to be a federal crime, and now they're reducing it to being, I forget what it is. Do you know what the difference is in this proposed law and the law that exists now?
I have seen that. I think the current carjacking law is an inappropriate federal law. It should be the states. It is their primary role to enforce those laws. And sadly, the carjacking, and I would also say the Hobbs Act cases, which is in essence now the robbery of a Kentucky Fried Chicken, for example. I mean, this is an example of the headline of the day driving the lawmaking and expanding the federal code.
Well, we'll have to look at that when a bill comes before our committee to see how we respond to it, because it's sometimes so easy to jump into something which is really state law.
Yes.
Mr. Fox, I was listening to your testimony. You were talking about respect for the law and all these laws, et cetera. Do you think that the pardoning people that attacked policemen just makes people think less of the law?
Yeah, I think it's a case-by-case basis. I think the federal justice system or even state justice systems really don't work well at all. So there's obviously problems, but blanket pardoning people who violently attack police and try to overthrow the government, yeah, that's wildly inappropriate.
Anybody think it was an appropriate thing to do to pardon all those 1,600 people in mass without going through them case by case? That creates a lot of people thinking it's who you know or what you do, et cetera, and just respect for the court system, because it was nothing to do with the prosecutors doing wrong or anything like that. It was just a class of people that he decided to do. And then there's been a lot of pardons lately. I don't know if you've kept up with them, but lots of folks in the crypto business who have been convicted, large monetary fines as well as jail time and tremendous amount of restitution, and they've been pardoned. And that's, it happens. It used to be that the presidents had some shame, and even if they gave a pardon to their brother or to somebody that gave them a ton of money, they waited until the last minute and they could get out of town. Now they put it on Truth Social and they parade it around, and then they appoint them to be an ambassador somewhere. Thank you. I yield back the balance of my time.
Gentleman yields back. Chair recognizes the chairman of the committee, Mr. Jordan.
Thank you, Mr. Chairman. Mr. Konoparo, what was the number? How many crimes? It was like 5,000. You had some number?
In the U.S. Code, we, with reliable certainty, estimated 5,199, but that's only the code.
That's only the code. So how many crimes are out there that aren't created by Congress but are created by the agencies?
We don't know for sure, but the number is almost certainly around between 300,000 and 400,000.
So Americans can be charged with all kinds of crimes that they don't even know exist, that they don't even know they broke, that were created by people they didn't elect. That's the situation we're in.
Correct.
Such a deal, right? Such a deal for Americans. This is how ridiculous it is. I'll give you a real life example. The ATF, out of thin air, said something that they had even said was legal, that had always been legal, said we're gonna now say pistol braces are illegal, and if you don't get rid of it, turn it in, destroy it, whatever, your property, if you don't do that, even though we told you it was fine years ago, even though there's nothing in the law that says it's a crime, you're gonna be a felon. It's crazy. So I wanna thank the chairman for bringing this together. I mean, you cannot create talk about lack of respect for the citizens of this country. They don't even get a say in the people they elect on most of this stuff that they can get charged with, which is crazy. How does that fit with our constitutional system, Professor Turley? I'll let you and Mr. Tolman talk a little here too. And we appreciate you all being here.
Well, it goes to what I mentioned earlier, that the danger of overcriminalization is it can change what being a citizen is. If everyone is potentially criminal in conduct that they engage in every day, it changes the relationship to the government. And by the way, it also has an impact on how people view real crime. So if everyone is a presumptive felon, if everyone is a mattress tag puller, if everyone can be charged with the discretion of a prosecutor for things that most people do, then you lose the stigma, the clarity for the real crimes. And that includes things like shoplifting. That is, you see the sort of casual attitude towards law breaking, but the government can be a terrible teacher in that respect by treating everything as potentially criminal, and then nothing's really criminal. It's just basically the government can either bring you into the criminal justice system or not based upon a whim or discretion. That has an enormously corrosive impact on the meaning of being a citizen, the relationship of individuals to their state.
Yeah, it diminishes respect for the law in general, and may lead to less prosecution of real crime, which Mr. Kiley just talked about. And then the thing that scares me, as much as both of those, is it encourages, I think, the weaponization of the government against people they don't like or who have a different political philosophy. And we have seen all three of those things in the last few years, which is, again, frightening and why this hearing is so important. Mr. Tolman, I'll go to you.
And one thing to keep in mind about the 300,000 plus regulations that have criminal penalties, almost all of those are white collar crime. So you're targeting you have the largest section of your criminal laws are actually targeting those that most likely have no criminal intent. And that's why we're seeing such ability of prosecutors without any proper accountability to use that against everyday citizens that don't have criminal intent.
So back to the mens rea for at least that.
Or at least that.
Yeah, that would make sense. I'll give the Democrat witness, which I normally don't do in hearings like this. I'll let you say something if you want, Mr. Fox.
Yeah, no, I agree. I mean, you know, the whole idea is you have to actually intend to commit a crime. Just doing something, you know, thinking you're trying to help someone, like saving a bunch of sharks from poachers, or there's another case where it was a man who was hiking on a mountain. He was, a professional runner, went up what unbeknownst to him was a closed trail. It had two tiny little signs. Now he's battling federal charges. There's another case, Lesh versus United States, it's pending in front of the Supreme Court, which was a snowmobiler who was charged for taking pictures, advertising his business, which is not what he was doing, but that's what they allege, while he was on federal land. And in a case like that, because the max penalty is 6 months in jail, according to the Supreme Court, despite that there's no textual basis in the Constitution or historical basis at all, he doesn't even get a right to a jury trial at all. So this is just government, like, you did something you didn't know was a crime, now you're guilty. And not only that, but of course, Congress never even passed these laws.
It's been one thing to shake him down, but they're going to shake him down and put him in jail potentially. It's crazy. Mr. Chairman, thank you for this good hearing. I yield back.
Thank you.
Mr. Chairman, I just have a UC request.
Please.
This is the federal justice statistics for 2023. Very interesting, 57,000 arrests, and 184 of them were for regulatory arrests, or 0.2%, but that may be too high given what was done. So anyway, for the record.
Without objection. Chair recognizes the gentleman from New York, Mr. Goldman.
Thank you, Mr. Chairman. Mr. Turley, it's good to see you again. You are a frequent witness for a variety of different hearings for the Republicans. And in fact, you testified in the last Congress related to an impeachment investigation. And as I recall, you testified that you believed that the Republican investigation related to Hunter Biden's private foreign investments did merit an impeachment investigation against President Biden, I guess based on alleged meetings that the president had with Hunter's business partners, even though there was never any evidence presented that they discussed Hunter's business ventures, or that the president ever financially benefited from those ventures. Is that generally an accurate assessment? You didn't call for impeachment, you just suggested there should be an investigation, right?
The purpose of that hearing was to determine whether there could be an impeachment inquiry and whether if
I'm just asking what you testified, Mr.
I'm trying to say that.
No, did you say directly that there was a legitimate basis to move forward with an impeachment investigation?
Yeah, what I said is that if those allegations were proven, they could amount to impeachable offenses.
All right. Well, let's focus for a second on some conduct that's been going on over the last few months. Related to World Liberty Financial. Are you familiar with that company?
No.
You're not familiar, okay. Are you familiar at all with Donald Trump's interest in cryptocurrency?
No.
So you're not familiar with the fact that Donald Trump issued a meme coin 2 or 3 days before his inauguration?
I saw something of that in the press, but I'm not that familiar with it.
Okay. Well, let's hypothetically, it's not hypothetical, it's true, Donald Trump has a financial interest in a meme coin named after himself. And he recently offered a VIP White House tour and special reception to the meme coin's 25 biggest holders. After that announcement, the coin surged more than 50%. Does that seem like something that warrants investigation to you, Mr. Turley?
Well, there's no question that you can investigate that to see if there was any criminal conduct. I want to distinguish between that and the influence peddling scandal that the hearing was about in the Biden administration.
I'm not talking about that hearing. And I know you like to filibuster, Mr. Turley. No, I'm happy to talk about that hearing. It was the biggest joke of an investigation. It was embarrassing that you call yourself a credible criminal professor, that you would actually think that there was any evidence that warranted an investigation. But I'm focusing right now because it would seem to me, if you have any credibility, you would agree that auctioning off a White House tour for the highest investors in your own company would warrant either impeachment or criminal investigation. But let me move on because it gets worse. The president is a significant financial beneficiary of a company called World Liberty Financial, which issues a stablecoin. Are you familiar with stablecoins?
I'm not.
Okay, a stablecoin is essentially a digital version of a dollar that can be used in transactions. Recently, the World Liberty, this organization which Donald Trump is a beneficiary of, entered into a deal with a UAE-backed company that would complete a $2 billion transaction with a company that has previously admitted to engaging in money laundering. And Donald Trump's company will now generate tens to hundreds of millions of dollars in revenue from that transaction with a foreign government. And I'm sure you're familiar with the Foreign Emoluments Clause, Mr. Turley. Would you say that based on that information, since apparently you only follow Hunter Biden's finances and not President Trump's, would you say that based on me providing you with that information, that would warrant an impeachment investigation?
Congressman, when you say that we have to preserve our credibility, I think you would agree.
Can you answer the question, sir?
He's trying to answer the question. Your time has expired. I will allow the gentleman to answer the question.
Thanks. In the interest of credibility cited by the member, I'm not going to rely on the facts that you just gave me for the first time to render a judgment on it. I'm not opposed to investigations of alleged corruption. That was the point of the previous hearing. But the way to establish credibility is not, as you did, sir, just engage in personality attacks and personal innuendos. I'm happy to speak with you and to work with you about anything dealing with corruption in this building. I've been writing about that for 3 decades. I've been called as a witness for both the Democrats and Republicans dealing with that.
Well,
but the way to presume,
I've only seen you as a witness.
Your time has
for the
expired, sir.
Republicans.
Your time has expired.
I'm happy to yield back.
Did you finish your question?
only that the way that we can actually regain.
I thought my time has expired.
Your time has expired. I said your time expired. He gets an opportunity to finish answering the question. You attacked.
I'd like to reclaim my time.
No, you have no additional time. You are out of order.
He's answering
Be quiet.
my question.
You are out of order.
I would like to reclaim
you cannot,
my time.
No. He's answering the question because you personally attacked him. I've said he can answer the question. I give that courtesy.
How did I personally attack him, Mr. Chairman?
You attacked his credibility. We're not going to get into
That's not a personal
we're
attack.
not getting into this right now. What we're going to
He's
get
a witness. His credibility matters, sir.
You are out of order. You are out of order. You're done. You can't say anything else right now. You may finish answering your question.
Thank you, Mr. Chairman. I think that the one lesson from this exchange is that it's possible that we can restore credibility in this institution if we can just get beyond the personal attacks.
There were no personal attacks, Mr. Turley. You are a
were
witness.
done.
Your credibility matters.
You, sir, you have lost your credibility with me. I gave that courtesy to everyone on this bench.
Mr. Chairman.
You ask a question, if they wanted to continue to answer beyond the time limit, I said, time's expired, you may answer the question. That's my routine, that's what I did today. You challenged him, asked him a question. You wanted an answer. Your time has expired. He is answering the question.
Mr. Chairman,
You don't
I
like
have a
his answer. Because you don't like his answer, you want to shut him up. What's your inquiry?
My inquiry is when you offered when my time was up at 00 for him to answer the question, he went and answered the question. You then gavelled and said my time was up.
That's not a parliamentary inquiry.
You gavelled and
That's
said my
not a
time is up.
parliamentary
I would like
inquiry.
to know when
That's not a parliamentary
my time
inquiry.
is up and when he gets to continue answering
That is not a parliamentary inquiry? Your parliamentarian's about to tell you. That's not a parliamentary inquiry.
He actually disagrees. He thinks it is a parliamentary
That's not a parliamentary inquiry.
Why? I'm asking for the process question, the process question as to when my time is up, which you allowed him to answer the question. You then gavelled and said my time is expired.
Yeah.
And then you then offered him to answer the question again, which he already had done.
No, sir. If we were to watch.
You did it based on accusations that I was personally attacking him, which I was not.
Excuse me. Not only are you out of order, you're being incredibly rude. Here's the deal. I gave everybody the same courtesy. You didn't like where he was going. You began interrupting again, but your time was expired. He was trying to answer the question. You didn't like the answer.
That is false. I'm happy to have this answer.
No, that's what happened.
I didn't like the accusation that I was personally attacking him. His credibility.
I didn't say that till the third round when you interrupted.
And
you continue to interrupt. You continue to be out of order.
And then I asked you,
are out of order.
I asked you, what am I personally attacking? And you said his credibility, and he is a witness. His credibility matters.
You're out of order. You are so far out of order.
Well, you are not conducting this in a fair and equitable way.
Sure I am.
Because
everybody got the same courtesy. You asked a question, they're going to finish answering. Everybody got that same courtesy. You interrupted him while he was giving the answer. That's why you got gavelled.
And then
you got interrupted.
And then you said
you interrupted.
My time,
that's why
and then you said my time is up, which is when you would go to the next person.
I gave the same courtesy to every member on your side of the aisle as I gave over here. When your time was expired, 5 minutes expired. If they were in the middle of answering the question, I let it go. Now we can talk about that round and round all you want. That's what I did. That's what I do.
Well, I look forward to you continuing to do that.
Yeah, well, good. And I look forward to you being in order next time. So, Mr. Turley, you may continue to answer the question that he so much doesn't want to hear.
I've never been so certain in saying I'm happy to move on.
Very good. Thank you. Now, I'll yield to myself 5 minutes, and we'll go through this. And Mr. Konoparo, you talked about something I thought was very interesting, and that was trying to resolve the agency overcriminalization, where you said what we could do is put something forward where the agency would actually adduce the number of crimes that they have, determine what they actually have to have, and then, all the rest would be avoided. Can you expand on that?
Sure. I think that given the sheer number of such crimes that are on the books, that's probably the best way to proceed. If you ask them just to say, maybe through the Department of Justice, for instance, just say, give us the list of all the regulatory crimes, I fear that what would probably happen is that you would not get a list. It may actually be impossible. So what I think the better solution would be to do is to say to the agencies directly, all of you agencies that have any sort of criminal enforcement regulations or criminal enforcement authority, you must, by a specific date, give us the list of all of them. And any that you have which are not in that list are immediately voided, so that if the next year they tried to prosecute somebody with one of these arcane regs, that person could say, I have a defense that has been voided by this statute. And I think that's probably the most efficient way to both count and cut at the same time. Because my fear is that if you just try to count, you won't actually ever get a number.
I don't disagree with that. Professor Turley, you said you wanted to wall in prosecutorial discretion because it seems to be a problem. And I would suggest to you that a blanket mens rea statute might do that. Do you have any other ideas on how to wall in the prosecution?
Well, we have two sets of criminal laws that we've been discussing. One is the most direct, which is in the criminal code for laws passed by Congress. And then we have this massive unknown body, really, of agency crimes that were basically written by the agencies. That's why we don't have really any walls. There are no walls. It basically is almost covers the same expanse as civil conduct. And you can't have a legal system like that, I think, without fundamental problems for citizens. So the idea is that prosecutor discretion is supposed to exist within a walled space, where you define that space, that this is the specific conduct. And you're absolutely right. If that space is defined by mens rea, then prosecutorial discretion really works quite well. And I want to say that I really am intrigued by Mr. Konoparo's idea that you can ask the agencies, what are the crimes that you are enforcing, and just presume that everything that they don't mention is obviously a crime that's not that important to them. And we're going to have to engage in sort of categorical eliminations. You're talking about hundreds of thousands of crimes. So you're going to have to find some way to make deep and serious cuts, and the agencies can actually give you the map for that.
Thank you. Mr. Fox, while not explicitly mentioned in your written testimony, you've written about trial penalty in the past. Can you briefly explain why one of the problems we're talking about today, too many laws on the books, contributes to the perpetuation of the trial penalty?
Yeah, absolutely. Thank you, Mr. Chairman. So the trial penalty is the difference in the sentence that you're offered at a plea stage and what you would get post-trial. In theory, it should be the same, because if it's not the same, there's something changing there. And there's a number of ways that prosecutors can coerce people into pleading guilty. Someone before mentioned charge stacking, that's just filing multiple charges. They can threaten family members, threaten to re-indict as a habitual offender, use pretrial detention. And I was a public defender. I had clients who would be offered plea deals that they could walk home that very moment while the prosecutors were arguing that they were a danger to the community and needed to be held on bond if they were going to go to trial. Obviously, those two things cannot simultaneously be true, so that's another way that they frequently do that. They've even been able to threaten to impose the death penalty against people just to get them to plead guilty. And when you have things like mandatory minimums that tie judges' hands, so if they go to trial and are convicted, there's nothing the judge could do but impose the sentence that he or she is bound to impose. And then absent juries who are, able to ask questions like, what would the sentence be if I convicted? Or is this something that I think is appropriate as a member of the community to prosecute someone for? There's sort of, prosecutors have unbridled discretion. I will say, I also wrote recently, there's two federal judges, Judge John Kane in Colorado, Judge Jed Rakoff in New York, both of which Judge Rakoff actually said that the point reduction for accepting responsibility is unconstitutional, and Judge Kane said that he will not apply it for the same reason. And the argument basically is you're getting a reduction in sentence because you're pleading guilty. That undermines your Sixth Amendment right to a jury trial, and the right to a jury trial is the only right that exists twice in the Constitution. It's both in Article III and in the Sixth Amendment. So really, judges need to aggressively police plea bargains and not just blanketly, do whatever prosecutors ask them to do.
Thank you. Thanks for that. Thanks to our witnesses for being here today. It's kind of fun till the end, right? Appreciate you being here and your testimony, and we will adjourn this meeting.